right. Welcome, everyone. Welcome. We still have some people joining us, but we're going to go ahead and get started because I know you all have things to do with your day. Well, if you haven't guessed by now, I'm Liz. You're having lunch with Liz today, figuratively, not literally. We're not delivering any Subway sandwiches to you this afternoon. I really appreciate you being here. I've always said I'll do this if there's just one person, but it's always good to have a few more people so we have more energy, more questions. So the idea is you're going to leave today knowing more than you knew before. And if you don't know more than you did before, I certainly didn't do my job. I specifically started Lunch with Liz. This is our fourth anniversary this month. I specifically started it to have conversations, not to just put out a webinar that no one could ask questions or a podcast that no one could ask questions, but where we could have a conversation so that I could make sure that the things I'm talking about are clear. So there's going to be ample opportunity for you to ask questions today. And you can do that a number of ways. You can do that in the chat. You can come off mute and ask a question. And you can also come off video and let me see your beautiful face and ask a question. But I don't require you to come off mute. I don't require you to come off video. If you just want to throw your question in the chat, I will get to it for sure. I don't jump on the chat every slide, but as it makes sense, I check. And then at the end, I'm going to open it up to all sorts of your questions and musings. So how it will work is I do have some slides, as you can see, only 14, and one's an opening slide and one's an ending slide. So not very many slides, but I do think some of us learn more visually than listening to someone talk. So I like to have both of those things out there. So today I do want to do a quick disclaimer. That I think some of the advertisements said that you would have everything you needed to know through this Lunch with Liz presentation today. That might be a little stretch. I'm not going to promise you're going to know everything you need to know after we're done talking today, but I do believe you're going to learn things you didn't know, and you're going to have yourself better set up with ways to protect yourself and your family going forward. So moving on, this is essentially the outline of what we're going to be talking about today. First, we're going to be talking about things like powers of attorney and medical directives. And I describe this as your incapacity planning. These are the documents that are in effect and are important while you are still alive. And we'll talk about what they do, how they work, and some important pointers before you go out and get one of those. Then we're going to talk about your death documents, whether that's a last will and testament or a trust. And we'll just hit a little bit on probate avoidance. If you are a probate avoidance junkie and you want to learn more, we have a whole hour Lunch with Liz set next month on, I believe that's May 14th, the second Thursday of May. A whole hour on probate avoidance, which includes things that you can do without needing to come see a lawyer to do your best to try to avoid the probate process. So let's go into the meat. Why do we want to plan? Well, I mean, not having a plan is actually a plan, right? It's just probably not a very good one. When it comes to estate planning, if you don't put something in place, Florida law has a plan in place for you. And generally speaking, it's not going to be one that you want, and certainly not one that your beneficiaries or loved ones want. It generally is going to require a probate case being opened, which means a judge is in charge of overseeing the distribution of your assets and payment of your debts. And there will be a delay in getting assets to your heirs, and maybe no assets to your heirs if there are debts involved, and the debts get priority for the most part when it comes to probate cases. Florida law also has a specific way that your assets go if you don't have a plan in place. And that might not be the way you want it to go. I'll give you an example. I have clients who are couples, long-term couples, cohabitate even, but they're not married and they don't put any documents in place. So what can happen is with one of the partners passes, all of their assets go to their family members, whether it's a parent, a sibling, a child. And now that long-term partner who, thought that they had a place to live or thought that they had assets to live on no longer does. So that's an extreme example of how that can come to fruition if you don't put your own plan in place. And I've also seen it where they tried to put a plan in place, but it was a DIY plan and it really backfired. And let me just hit on that real quick. It was a long-term couple again, and the way they earned their living was investment properties. So they owned about 15 investment properties throughout the Tampa, St. Pete area. Well, one of the partners dies. And what they didn't realize is that in all of the deeds, they owned the deeds as tenants in common. Both their names were on the deed, but the language wasn't there to ensure that when one partner died, it automatically went to the surviving partner. So when that one partner dies, guess what? 50% of all of those properties went to her estranged daughter who didn't even like the partner who lived. A couple extreme examples, but these are common things that happen when people don't think about putting a plan together. So what we're going to learn today is some things you can do on your own and some things you're probably going to want to go talk to your CPA, your financial advisor, and your estate planning lawyer about. All right. I'm going to, hit this nail over the head as many times as I can about why planning is important. We just talked about how not planning is a plan, but this is some of the reasons why it is so critical for you to put a well thought out plan in place. And when I say well thought out, I'm not saying a complicated plan. My philosophy is when I'm dealing with my clients is what's the simplest way to accomplish your goal? If we have to get complex, we have to get complex. But by and large, we can stay with a fairly simple plan and still accomplish whatever your goal is. Not 100%. Obviously, there are situations out there that require complex planning. But for the most part, I can get people where they need to be in more of a simple way. But this slide really highlights some of the reasons why you need to make your plan. And I'm not going to go down through them all, but these are some things that when I'm talking to my clients, this is one of the first things we talk about, because in order to put a plan in place for them, I need to know what their situation is and I need to know what their goals are. All right. So remember when I was talking at the beginning, when we had the intro slide, I said we're going to break this into two categories. One is your incapacity planning, and the other is planning for death. So the initial couple of slides here are going to be talking about incapacity planning. And when you think of incapacity, you think about, a lot of people think about a stroke or maybe dementia or Alzheimer's, but it could also be a short-term incapacity due to a car accident or a slip and fall, or other type of medical issue where you're just not able to take care of your affairs for a short period of time. Obviously, it can also deal with long-term incapacity regarding Alzheimer's, dementia, stroke, or other issues that regarding cognitive decline that don't let you make your financial or medical decisions. So the first document, and if I had a soapbox to stand on right now, I would be yelling that this is the single most important document to have, in my opinion. You could Google that, and there will probably be other people that say a different document is more important. But I've been practicing 30 years, quite a while. And this is the one document that if you don't have it, there's significant repercussions for you while you are still alive. If you don't have a power of attorney in place that gives your trusted agent these authorities to pay your bills and make your financial decisions, then what your family or your loved ones have to do is hire a lawyer for thousands of dollars, go to court for thousands of dollars, get a guardian appointed for you. And now this guardian is the one that's making the decisions for you. Um, in most situations, when a family or loved ones petition for guardianship, they ask for themselves to be appointed. But that doesn't always work that way. I'll give you a quick example. I had a case a couple of years ago where this couple had been together for about 20 years, never married. He lived with her in her house, and then she had a cognitive issue and was no longer able to make her financial decisions. Of course, no documents were in place at that time, no power of attorney, no medical directive. So he was forced to hire me to open a guardianship to get appointed to take care of her affairs. Well, guess what? Her family from, I think they were South Dakota, nothing against the fine folks from South Dakota, but they petitioned to be guardian. So we had a 2-day hearing down in Sarasota, and ultimately the judge decided that it was family that deserved to be the guardian and not this 20-year partner of this woman. That's an extreme case again, but it shows you the possibility that if you don't have these documents in place, what you think will happen for you won't happen. And someone that you didn't even have a relationship with could be appointed your guardian and is in charge of your money and your medical care. And if it's not a family member you don't want, it could also be a complete stranger. It can be a professional guardian. I know there's some recent movies out there highlighting some of the guardianship issues. So when I say my soapbox is this is the most important document, the reason I say that is because if you have it, it can usually prevent all of those other issues regarding guardianship. And it lets you pick that person who you trust to make these decisions while you are still, perfectly fine cognitively. And when I say choose your agent carefully, you'll see that on both slides. You'll see that on the slide for financial decisions, and you'll see it on the next slide for medical decisions. We walk through this decision carefully when I'm talking to my clients because I think some people are inappropriate to be in this role for you. So we will definitely talk through the decision-making process when you're picking your agents. Long story short, if they can't even balance their own checkbook, you don't want them trying to balance yours, for example. The next documents after we're talking about a financial power of attorney is your advance directives. I lump them into just a one broad category called medical directives, but you're probably used to hearing the words living will, healthcare surrogate. Some people use the term medical power of attorney. Those are all pretty much interchangeable descriptors of these documents that dictate what happens to you regarding your medical care should you not be able to make these decisions for yourself. The living will specifically lets you make decisions ahead of time about whether you want to be kept alive artificially or not. Some people don't have an overwhelming care one way or the other about this, but I would say the vast majority of my clients have strong feelings either one way or the other. And it's important to put this down on paper. It's also important because I will fight you if you're my client and you tell me that you're just going to let your family decide, because that is a very traumatic, very difficult position to put your family members in. And what happens if they don't agree themselves or they disagree about what you thought or what you wanted? So putting your wishes down on paper is extremely important to preserve the sanity of your friends and family who are going to be charged with carrying this out if you can't make these decisions yourself. The healthcare surrogate designation is like the medical power of attorney term. It names someone to make these decisions for you in the event that you can't make them yourself. It allows them to access medical records and carry out your living will wishes. What I talk to my clients about is don't jump right away to who's going to pull the plug, right? Or who's not going to pull the plug. That kind of stuff happens, but the vast majority of healthcare surrogate work is simply advocating for you, advocating to make sure that your healthcare is on track, that you're getting the treatment that you need, that you're getting in the facilities that you need, the rehab that you need. So I highly recommend you pick that family member or loved one who is the greasy wheel, who or squeaky wheel, sorry, not the, I guess a greasy wheel would be quiet. So you want a non-greasy wheel to make these decisions for you. It's great if they have healthcare background, in my opinion, but it's certainly not a requirement. It's just someone that can advocate for you. In both, I didn't mention this in the power of attorney, but in both the power of attorney and the healthcare surrogate, I discourage joint actors. So when you think about, let me flip back to the power of attorney. I do not name joint actors when it comes to powers of attorney. So that means if you have two kids and you just can't decide, we have to flip a coin and decide because one person has to be in charge of the money. If you make it two, there are a lot of banks and financial institutions that simply won't recognize two people acting. So I simply won't write a power of attorney in Florida that has joint actors. In a medical directive in your healthcare surrogate, I will after we've had a long talk and you're adamant, but I still don't think it's a good idea. Yes, people are going to talk and make a decision together and collectively come up with a course of action, like if you have 3 kids or something like that. But ultimately, you need that one decision maker. So if there is a disagreement or if the doctor just needs to talk to that one person, you have that person identified. All right, so I already talked about guardianship. That's the next slide. I got a little ahead of myself because I got excited about being on my power of attorney soapbox. So I won't belabor this slide, but this one just highlights again what can happen if you don't have these incapacity documents in place. So now we've talked about incapacity planning. And before I move on to your death documents, I'm just going to check the chat real quick to see if we have questions specifically related to incapacity. Greg, I don't know what that question is about, how many. So if you want to clarify that or if it matters, let me know. But Catherine, does the 5 wishes document work well for this as well? 5 wishes works well for making sure that your advocate knows what your wishes are. And there's the 5 wishes. I have a dementia directive. I have a living will form. I've seen documents from other states that I've adapted. If a client comes from that state and they liked how that state did it, I've kind of formulated a specific one for a client. So yes, all of those things are helpful to let your advocate know and your medical professionals know what your wishes are. But ultimately, you need your healthcare surrogate named so that they can make those decisions and carry your wishes out. All right, so I think that's all the questions we had on that. If you have questions about powers of attorney and medical directives, we can address those again at the end as well. So don't think you've lost your opportunity. Now we're going to shift gears to estate planning. What people think about when they think about estate planning, right, is what happens when we die. I used to, when I was a baby lawyer, say what happens if we die, but it's become readily apparent now that I'm in my 50s that it's actually going to happen at some point. So now I use the appropriate term when we die. These are some of the things that's up on the slide right now that we'll talk to clients initially about, because in order to put a plan in place, I have to know what their goals are, what their worries are. And depending on their situation is going to dictate the kind of tools we can use to plan. If you have a blended family, kids from other relationships, you have minor children, special needs beneficiaries, if you have those types of things, you fall into the complex category. It is going to be a little more complex, usually a trust-based plan to accomplish your goal when it comes to that. But we also talk about other issues with clients, whether caring for their pets are important and caring for special charities or their alma mater is important. Whether they have assets in another country or another state is vital to understand so we can put a good plan together. And I don't have a lot of these clients given this current estate planning, estate tax threshold, but we talk about estate taxes because We don't know what that threshold will be when we pass away. Right now, for an individual, it's around $14 million, and for a married couple, it's $28 million. Certainly have clients that reach that threshold, but the vast majority don't. But we have to worry about a different administration in power in Washington, D.C., who might lower that threshold. So we still have to think about planning for estate tax purposes. Once we've talked about this, in the initial consultation, we're going to decide what kind of plan we put in place. And is that a will-based plan or is that a trust-based plan? So what is a will? What is a last will and testament? It's a legal document that takes effect when you die. And if you have assets that are governed by the will, and that's an important caveat that I'm going to talk about on this slide. But if you have assets that are controlled by the will has to go through probate. I'm going to say that again. If you are relying on the will to transfer your assets, it must be probated. I've heard that myth out there a lot that, well, I've got a will, so I'm going to avoid probate. That's not the case. Again, if you are relying on a will to transfer your assets, you're going to go through probate to transfer those assets. The will also dictates who the guardian of any minor children will be. I can also put in there what happens to pets if that's important to you. It names your personal representative. That's also referred to as an executor, but in Florida, we call it a personal representative. Names your beneficiaries, who you're wanting to leave your things to. So it doesn't matter what Florida law says for the most part. If it said if you didn't have a plan, everything goes to your brothers. If your will says it all goes to charity, then the will is going to dictate what happens to your stuff. There's a few exceptions to you being able to override Florida law. For example, you can't disinherit your spouse without a pre or postnuptial agreement, and you can't disinherit minor children. But you can disinherit adult children, just FYI, in case that's an idea that you have. And you can disinherit siblings, and you can disinherit parents and that sort of thing. It's important that the will is witnessed and notarized appropriately, and best practice is that it has a self-proving affidavit. This is why I don't like do-it-yourself wills. I don't like do-it-yourself wills because, number one, people don't understand that a will doesn't avoid probate. And two, they're often either not witnessed and notarized appropriately, or they don't have a self-proving affidavit. And you don't need to know what that means, that legal gobbledygook, other than if you don't have one, you have to find these witnesses to get the will entered into the probate process, and they may have already passed on themselves. So it's important to have that self-proving affidavit. So that's all on this slide. We're going to circle back to the will thing, though, just so you know. We're going to talk more about if you're relying on a will to transfer assets, and we're going to talk about that during the probate avoidance part of this talk. The next document that's in our toolbox that I'll consider using based on your circumstances and your goals that we've already talked about, right, is a revocable living trust. Living and revocable are redundant. I typically don't use them together. What it means, either living or revocable, is that the trust is amendable. You can change the trust. You can take things in and out of the trust. For me, I like to think of a trust like a bucket. Different lawyers use different analogies. The bucket analogy works for me. So when I draft a 50-page trust for you, think of that 50 pages as a bucket. And so now Liz has a bucket, and I'm going to put those instructions on the outside of the bucket. Well, when I draft that 50-page trust and I give it to myself, I'm passing myself an empty bucket. So for that trust to make sense, to work at all, I've got to put stuff in the bucket. And that's what we mean by funding the trust. And I cannot tell you how many times in my practice I've seen people come in whose spouse has died or parents have died, and they've said, see, I have a trust. We don't go through probate. But they never put anything in the trust. They never retitled assets in the trust. They never made the trust the beneficiary of assets. So now we have the worst of both worlds. because not only do we have to probate um, the assets that were there, then we have to put them in the trust and then go through a trust administration in a lot of the scenarios. So we're doing two things there that we wouldn't have had to do if the trust had been appropriately funded. Another reason why I don't like do-it-yourself documents is no one's there to guide you through this funding process, which is critical. It makes no sense to have a trust without it being funded. Do you need a trust to avoid probate? This is the second thing that I want you to take away from this. Well, it's the third thing because the power of attorney was the first. The will doesn't avoid probate is the second. The third one is, do I need a trust to avoid probate? And the answer is no. The answer is no. I would say 60% of my clients I can get to, Florida clients I can get to avoid probate without a trust. And we're going to talk about that. There are other kinds of trusts out there, but I'm not going to get into that today. We don't have time for all of that. All right, so let's talk about some probate avoidance and some things that you can do yourself. I wish I hadn't put joint ownership first because it's not my favorite, unless you're a married couple, in which case it could work. But what I see is mom or dad putting son or daughter or niece or grandson on accounts. That can work, but it also can backfire. If that daughter, son, grandson, niece, whoever gets into an automobile accident and gets sued, well, that account that she's joint owner of now is part of their assets and could be attached through that lawsuit. If that person that shares the account with you files bankruptcy, that is an asset that could be considered theirs through the bankruptcy court. Also, they can just wipe the account out. So just be very careful about adding someone as a joint owner on an account. Other things I've seen is where parents put one child on the account when they have 2 or 3 or 4 or 5 kids. When they die, that account is legally the person's whose name was on the account. Well, they have 4 siblings that mom and dad's intent was they're going to share that money. I'm going to let you in on a little secret. When it comes to money, people can change, and it is not at all uncommon for someone who gets a joint account because they were a joint owner for a parent or sibling or something like that to simply not share the money. They don't have to be forthright about it. There's no legal recourse for that. So be very careful about adding people's names on accounts just for the probate avoidance process. Also be careful about adding people's names on deeds. You have gifting issues, you have taxation issues, you have homestead issues. If someone needs to get on Medicaid, you could have Medicaid issues. So before you add a joint owner on anything, I would talk to your financial advisor, your CPA, and your estate planning attorney, just to make sure that all the red flags are addressed and it makes sense that that's the way to go about doing it. Other less risky ways of avoiding probate are beneficiary designations. And there's different ways that financial institutions identify beneficiary designations. So I've put them all on this slide. Pay on death designations are typically related to things like checking accounts, savings accounts, money market accounts. These are your cash depository accounts. And a lot of people don't realize you can put beneficiaries on these accounts. You can put multiple beneficiaries on these accounts. And that is a great way for those checking savings accounts that we all have to avoid probate with those accounts. For transfer on death, that's typically the nomenclature we use for things like certificates of deposit and brokerage accounts. Because we're not paying cash, we're transferring ownership of stocks or mutual funds or whatever is in those CDs or brokerage accounts. So all of those types of accounts can have transfer on death designations. So it doesn't matter what your will says, doesn't matter what your trust says. If you have beneficiary designations on checking, savings, money market, CDs, brokerage accounts, that's who those accounts are going to go to. So when I said a will, if you have a will, you don't avoid probate. remember what I said was if you have a will and you're relying on that will to transfer assets, you will be going through probate. But if you transfer assets with pay on death, transfer on death, and other beneficiary designations, we can typically avoid probate with those types of assets. Same thing with your retirement accounts, whether that might be an IRA, a 401k, a SEP, 403b, annuities. All of those will have beneficiary designations on them. So ultimately, when I have clients that are going with a will-based plan with a probate avoidance plan of beneficiary designations, their homework when they leave my office is to go check. If they think that someone's listed, I make them go make sure someone is listed on all of those accounts so that it corresponds with their estate plan. The last thing there is how we, in a simple will-based plan with probate avoidance with beneficiaries, we use the Ladybird deed for real estate. It doesn't work for everybody. I would suggest you talk to your estate planning lawyer about it because it has its pros and it has its cons, but it is a way to put a beneficiary essentially on a deed. So let's take me, for example. Let's say I own my condo and I want it to go to Tracy when I pass away. So I will do what's called a Ladybird deed and I'll deed the condo back to myself. And the deed will say that I have the rights to sell the condo, to refinance the condo, to take Tracy off the deed, whatever I want. But that as long as she's still on there when I die, then the condo automatically passes to her without probate. So I have a couple of scenarios next that I think can help illustrate some of the things we've just talked about. So this is the non-trust probate avoidance example. So in this case, we have John. John owns his house. He has a checking and savings account, a brokerage account, a retirement account, and life insurance. He has no spouse, no kids. And let's say it's Tracy's banner day and she's the beneficiary for John too. They go way back to the bar last week. So he's going to leave all his stuff to her. So we can do the Ladybird deed. So it will say John owns the house. John's deeding it to himself for his lifetime, but upon his death, it goes to Tracy. So that takes care of the house. He puts pay on death designations on his checking and savings and money market. So that goes to Tracy. For his brokerage account, let's say he puts Tracy, or maybe he really was a cat guy and he wants it to go to Friends of Strays or something like that. So he could put them as the beneficiary designation on the brokerage account. And then his retirement and life insurance would have Tracy as the beneficiary or whomever as the beneficiary. So now all of his financial assets in his house goes to the beneficiaries that he wants without probate. Then we use the will that we've done to dictate what happens to his personal property and his vehicle. One vehicle is exempt from probate, so generally we can avoid probate with that. If there's more than one vehicle, then I have other options that I advise the clients to do to avoid probate with the vehicles. So you just got the scenario of probably 60% of the people I see in my practice, how we can avoid probate. Note what's missing here, though. There's no special needs children. There's no minor children. There's no beneficiary with drug or alcohol problems. There are no blended families. So this is a simple scenario. And because it's a simple scenario, we have a simple, less complex, less expensive plan to avoid the probate process, but yet still accomplish his goal and get the money and the assets where he wants them to be. Now, my next scenario is using a trust-based plan for will avoidance. In this case, it's Sarah, and Sarah owns her house in Florida, a condo in North Carolina. She has other accounts like checking and savings and retirement. So in this case, the reason I would suggest the trust-based plan is because she owns that property out of state. So thinking back to my bucket analogy, we've created this bucket. We've created Sarah's bucket. And in it, she's giving these assets to whoever she dictates, right? And we deed the property in Florida into the bucket, right? Because you have to fund the bucket. You don't want an empty bucket. So we deed the property in Florida into the bucket. We hire an attorney or a title company in North Carolina to deed that property into the bucket. And we retitle her brokerage, checking and savings. We might make the trust, the bucket, the beneficiary of her retirement and life insurance. It just depends on what she's trying to do with it. If it just can go outright to someone and she's not trying to control from the grave, I'll just tell her to put that person or people on as a beneficiary. But if she is, let's say, trying to care for her sister's minor children through distributions over time, then we're going to want the retirement accounts and the life insurance to list the trust as the beneficiary so that when Sarah dies, her bucket is full of all her assets. And then the instructions that we've written in the trust will dictate what happens to those assets without needing to go through the probate process. So I know we have some questions in the chat. So let me go through those first. And then if you have other questions or you want me to elaborate on something, then just pop off mute and let me know. Let's see. Is a spouse the default medical surrogate in Florida? Yeah, the answer to that is yes. There's the statute is in chapter 765 if you have a hard time sleeping at night and you want to read the statute. And it lists in order who the preferred surrogates are. And a spouse is number one. And then I think adult children are number two, and then other family members three. And that's why I'm not as high on my soapbox about the medical agent, because there is a statutory guidance about who the preferred person would be. Not the same for a power of attorney, though. You don't get that. And just because you're married doesn't mean you get to make financial decisions for your spouse, which again, let me get back up on that soapbox and why the power of attorney to me is the most important document. Next question. How often should someone review or update their estate plan, or what life event should trigger a change? That's a great question. Big life events like death, divorce, moving, the birth of a child, those are all important life events that you would want to revisit your plan. I think a yearly basis is a good idea to revisit the plan because relationships change. The person that you trusted last year might not be the person you trust this year. They might have medical issues of their own, so can't serve in a capacity, or maybe they won the lottery and you don't need to provide for them in your plan anymore. Maybe you had restrictions on distributions, but it turns out that, they don't need those anymore. So a yearly basis at the least about every 3 years, I would revisit your plan just to make sure it really jives with your current life events. Buying significant assets, you want to make sure that those are either in your trust if you have a trust-based plan, or you've triggered some other mechanism for those to go on to your beneficiary, whether that's a beneficiary form or transfer on death form or something like that. For IRAs, can the designated beneficiary just transfer the account into their names? No need to set anything else up to make sure the beneficiary doesn't have to withdraw the funds. Yeah, so with an IRA, and I know there's some financial people on here that probably are better at answering this question than I am, because just because my last name is Moneymaker doesn't mean I know anything about all of that stuff. But yeah, when you name someone as a beneficiary on an IRA, then they inherit that IRA. And there are different rules. Some of you might have heard of this act called the Secure Act that was passed by Congress 5-6 years ago. That made some rules about how quickly a beneficiary has to withdraw from that IRA. So if they're a non-spouse, and if you're a financial planner here that knows more about this, please feel free to pop on. But if you are a non-spouse, I'm sorry, if you are a spouse or a minor child, then you have different rules about your withdrawal from that IRA than if you are not in those categories. So one of the things I talk to my clients about is who who does it make sense to be the beneficiary of some of your qualified accounts, your tax, um, your your tax deferred and your otherwise retirement accounts. Um, but when you say make sure the beneficiary doesn't have to withdraw the funds, depending on who they are, what relationship they are to you, they may have to withdraw the funds. Um, if you establish a ladybird deed, does it need to be identified in the will? No, I don't identify the ladybird deed in the will, but what I do is I do a backup designation in the will in case the ladybird deed fails for some reason. Let's say the legal description was wrong, or I don't know. I don't know why else it might fail, but for whatever reason, the ladybird deed doesn't get filed, something happens. I want to make sure that there's a backup to what you wanted to have happen to that house. So let's say you're leaving the house to Gary in the ladybird deed. I'll specifically say we're leaving the house to Gary in the will. Um, the will also, we can list backup, contingencies for Gary receiving the house. That is one of the drawbacks to the ladybird deed is I can't put contingency planning in there. Like if Gary's dead, then it goes to Paul. Can't do that on a ladybird deed, but I can do that in a trust or I can do that in a will. So those are some of the things I'll talk to my clients about before we settle on using the ladybird deed as a tool. Is there a way to leave a deed condo to two adults? Absolutely. I mean, you can do that via the ladybird deed. You can do that via a will. You can do that via a trust. And what I would talk to my clients about is who are these two people you're leaving it to? Do they know each other? Do they like each other? Because they're now going to be joint owners of a piece of property. And that could either go really well or really, really poorly. So, and you don't have a crystal ball about that, obviously, but you want to kind of think that through a little bit. Can the title company that's hired also look for any liens on the property? I'm concerned about fake liens and wonder how to find out about monitor them over time to make sure property is free and clear. Yeah, a title company can look into liens. You can also put an alert. Pinellas County, Hillsborough County, Manatee County, probably all Florida counties let you put an alert on their website, or you could sign up on their website so that if there's ever anything done involving your deed, then you get alerted to that. People who don't have mortgages, those are the ones that are really of concern for fraud when it comes to deed fraud. So if you fall into that category, I would highly recommend that you do that. And I, Vicky is my client services coordinator, and she's on here. And I usually try to give her a heads up when I'm going to refer something else and make her put it in the chat. But I didn't give her a heads up on this. But I think, Vicky, we have a blog about that or something. So if you want to share that with our group here so that they can go on and make that election if they haven't done so already. Um, Yeah, thank you for talking about the RMD age. That's why I would defer the retirement accounts and all of that to someone a little bit more where it's in their wheelhouse. Okay, thanks, Vicky, for doing that. So that's all the questions we have so far in the chat. I'm going to stop sharing. I think. Yeah, stop sharing. There we go. Anyone have any questions? I don't want to keep you here longer than you want to be or need to be, but I also don't want to go if you have questions, you're not sure about something I said, or you heard from your cousin's best friend's nanny something different than what I said, then I would want to talk about that to make sure that it's clear. If you want to talk about your specific situation, I offer complimentary consultations when it comes to estate planning. So you can either call the office or you can email Vicky, who can get you set up with one of those complimentary consultations. I'm sure that she's reading my mind and putting her email in the chat right now. I do those both in person at the St. Pete office, but also via Zoom because we help people all over Florida when it comes to estate planning and probate and Medicaid planning for that matter. Anyway, I'm going to stop talking for a second to see if you have any questions. If you're shy and you just don't want to ask a question in front of all these people, then I'll hang out a little bit after we close down and you can ask it then. But again, probably the easiest thing is just to come in for a complimentary consultation and we'll talk about all the stuff that's specific to you and what the pros and cons to all these plans are. If you know of someone who could have benefited from this, it is being recorded and it will be posted on our website and shared on our socials next week. So you can share that with them. We also have a library of prior Lunch with Liz's that are on the website for you to look at. One good one is, well, they're all good, right? But one good one to look at is January's, where we did the I'm Dead, Now What presentation, where we talked about what you can do ahead of time, put your affairs in order, like your account numbers, your digital assets, what your last wishes are, so that if you go out tomorrow and get hit by that proverbial bus, whoever is in charge of your affairs can just go in, look at that, one stack of documents and knows exactly what time your dog gets fed, what kind of pills the dog takes, where the vet is, where you want your grandma's ashes to go. All of those things you can have already spelled out. Is it a lot of work to do? Yes, but it is one of the greatest gifts that you can give your loved ones for sure. Next question. If you've hired an attorney to create a trust, what happens if that attorney dies? Would it be better to have a larger firm? Can you transfer a trust to another firm? Oh yeah. That's not a big deal at all. If the attorney who created your trust dies or retires or whatever, you would just go to a new attorney to either update that trust, or that attorney can, what we call it, administer the trust. So, put the trust language into action. So, I'm a sole practitioner myself. So of course I would say don't go to a big firm, go to a small firm that will give you the attention you deserve. But some people want that big firm experience and some people don't. So I'd say that would be the reason why you would choose a big firm versus a small firm. If you want to have access to somebody, even when they're, on vacation, even when they're on vacation, you probably want a big firm because they're going to have an associate that's going to cover for them. If you want to actually talk to the attorney and be able to get the attorney on the phone, then maybe you want a smaller firm. But it really comes down to who's the person that you're going to feel most comfortable with talking about these very personal topics. That's the most important thing to me, is who's going to listen to your goals, who's going to listen to your concerns and help you put a plan in place that you understand and can keep up with as you move through life. All right. Any other questions before I let y'all go? Don't forget, next month is probate avoidance, where we're going to talk a lot more. I hit that one slide for you. Well, the whole presentation is going to be about probate avoidance and how you go about doing that if that's something you're interested in. So we'll talk a little bit more about the trust-based plans and will-based plans with beneficiary designations. All right. Well, with that, I'm going to say I'm going to let you all go. Have a great rest of your week. And again, I'm going to stick around just a little bit if you're shy. Otherwise, hopefully, we'll see you next month.